I've seen a lot of things walk through my courtroom doors: liars in expensive suits, honest people in torn sneakers, people who think crying substitutes for facts, people who think volume substitutes for truth. After decades on the bench, first in Manhattan family court, now in this televised arbitration room, I thought I'd seen everything. I hadn't. If you believe that truth can hide in plain sight and that one small detail can change everything, hit that like button right now and stay with me. Because this case, this particular Tuesday morning, stopped the entire courtroom cold, including me. And I don't stop cold easily. The case file said, City of Millbrook versus Marcus Delaney, trespassing, petty theft, resisting a public ordinance. The kind of stack that looks like an open and shut nuisance case. The kind of file my clerk slides across with that look. The look that says, another one. I've handled 1,000 cases like this on paper, except this one wasn't like any of them. Subscribe to this channel right now if you want more cases from my courtroom, because what happens in the next few minutes will change the way you look at justice entirely. Marcus Delaney, 53 years old, homeless for 8 months according to the intake sheet, charged with sleeping on municipal property, specifically the covered walkway attached to the Millbrook Public Library, after multiple warnings from city officers. Additionally charged with taking food from a courtesy cart left outside a downtown church without permission. The city attorney wanted 30 days in county jail and a permanent ban from the downtown district, 30 days in jail, for sleeping near a library and taking food from a church cart. I looked at the file. I looked at Marcus Delaney. I leaned back in my chair. He stood at the defendant's table in clothes that were clean. Not new, but clean. That was the first thing I noticed. His hands were folded in front of him. Not fidgeting, not posturing. His chin was up, but not defiant. There is a difference between dignity and arrogance. I've spent my career reading that difference in human faces, and I was reading it now. The city attorney, a young man named Forsyth, sharp suit, overly confident posture, the kind of posture that hasn't been humbled yet, led with the ordinance violations. Municipal Code 14.7, prohibited camping. Code 22.1, unauthorized appropriation of property. He presented photos of Marcus sleeping under the library overhang. He presented a statement from a church volunteer who said the food cart was not intended for public access. I let him finish. Then I turned to Marcus. Mr. Delaney, you understand why you're here? Yes, ma'am. Good. He didn't call me Your Honor like he was trying too hard. He didn't say, I don't know why I'm here, like someone performing confusion. He said, yes, ma'am. Simple, respectful. I made a note of that internally. Tell me what happened, your version. And here, right here, is where I always learn the most. Not from the documents, not from the attorneys. From the moment a person opens their mouth and decides whether they're going to tell me a story or tell me the truth. The body language shifts. Some people get louder, some people get smaller, some people look at me, and some people look at the ceiling. Marcus Delaney looked at me. If you've ever seen someone tell the plain, unvarnished truth when they had every reason to dress it up, share this video right now. Because what this man said next didn't sound like an excuse. It sounded like a fact. He told me he'd been sleeping under the library overhang for 3 weeks because the city's overnight shelter had a 90-person capacity and was full every night he tried. He told me he had a spot on the waiting list. He showed me, his attorney handed me the paper, a printed confirmation from the Millbrook Housing and Social Services Department, a waiting list confirmation dated 6 months prior, with his name, his case number, and a current status notation. Active, no placement available. I looked at that paper. I looked at Forsyth. I said nothing for a moment. The bailiff, Gary, 22 years working with me, shifted his weight just slightly to the left. That's his tell. That means he's paying close attention. The clerk, Sandra, stopped typing. In my courtroom, when Sandra stops typing, something important just happened. Before I tell you what I found next, hit that like button and let me know in the comments. Do you think a man on a government waiting list deserves jail time for sleeping outside? Because what I'm about to show you goes much deeper than this charge sheet. Now, the food. The church cart. This was the part Forsyth leaned into. He produced a written statement from the church volunteer, a woman named Paulette, who stated that the cart was reserved for pre-registered program participants and that Mr. Delaney had helped himself without checking in. I turned to Marcus. The food cart. Tell me about that. He didn't flinch. Ma'am, I've attended that church's Wednesday program 4 times. They have a sign-in sheet. I signed in. The cart was outside, and I was told by a volunteer, not Paulette, that we could take from it while we waited. I took 2 sandwiches and a bottle of water. Do you have proof you attended that program? His attorney slid a document across to me. I looked at it. 4 sign-in confirmations from the church's Wednesday outreach program. Marcus Delaney's name was on 3 of them with handwritten check marks next to it. The 4th had his name with the note, arrived early, assisted with setup, assisted with setup. A man sleeping under a library overhang was helping a church set up its food program. Baloney, said my brain, not at Marcus, but at this entire charge sheet. I turned to Forsyth. Counselor, did you look at the church's own sign-in records before you filed this? He shuffled papers. He adjusted his tie. He said, the complaint was filed by the church volunteer on duty that day. I didn't ask who filed it. I asked if you reviewed the sign-in records. He had not. That's what I thought. Here's the truth about this kind of case. Nobody looks. They see homeless man, they see violation, and they reach for the charges like it's a reflex. Nobody stops to ask whether the ordinance is being applied to a man who is on the city's own waiting list, trying to use the city's own social services, and sleeping 30 feet away from the city's public library because there is nowhere else to go. Nobody asks that question. That's why they have judges. That's why they have me. Subscribe right now if you believe that evidence should matter more than assumptions, because I'm not done, not by a long stretch. I called a brief recess. I needed 5 minutes to look at something. Something in that file had been nagging at me since the moment I opened it, like a hangnail you can't ignore. I went back to the original police report. 3 officers responded to the library complaint. The report was filed by Officer Renata Cruz. I read her notes, and there it was. Right there, in the narrative section of Officer Cruz's own incident report, buried under the boilerplate language about ordinance violations, was a single sentence. Subject was cooperative and presented documentation of social services enrollment. Noted, subject appeared to be maintaining the area and had placed a cardboard windbreak to protect the library's exterior ventilation grate from weather damage. He had built a windbreak to protect the building. A man with nowhere to sleep, sleeping next to a public building, had fashioned a barrier to protect that building's infrastructure from winter wind. I sat with that for a moment. I'm not a sentimental person. I don't cry in my courtroom. I don't make decisions with my feelings. I make them with facts. But I'll tell you something. I've been doing this for a long time, and once in a while, a fact lands differently than the others. This was one of those facts. I came back to the bench. If you've ever seen someone do the right thing when nobody was watching and nobody gave them credit for it, share this video with someone who needs to see it today, because what I was about to find out next would make everything about this case different. I asked Marcus Delaney one more question before I let this go further. Mr. Delaney, before the last 8 months, what did you do for work? He looked at me steadily, not like someone bracing for embarrassment, like someone who had already made peace with his answer. I was a licensed building superintendent, 31 years. I managed 3 residential properties on East 74th Street in Manhattan for the same owner. He passed away. His family sold the buildings last October. I had 45 days to vacate my on-site apartment. It came with the job. I had no savings because I had no rent for 30 years, and I never thought I'd need them. I was 60 days from 62 when the apartment was gone. The courtroom was quiet. Not the quiet of people being polite. The quiet of people doing math in their heads and not liking the answer. Gary the bailiff was very still. Sandra was not typing. I looked at Forsyth. He had the grace to look slightly ill. Let me tell you something about 31 years. That is not a gap in work history. That is a career. That is a life. That is a man who knew how to maintain a building, 3 buildings, and who maintained them well enough to keep his job for 31 years with the same owner. And I'll remind you what we established earlier. When he was sleeping outside, he instinctively protected the building next to him. Some things are in your nature. You can't turn them off. Answer me this, I said to Marcus. The waiting list. Have you been actively engaging with social services, job placement, housing applications, the full program? His attorney handed me a documentation packet. It was thorough. Housing applications, 7 of them with dates and case numbers, 3 interviews with workforce placement agencies, 2 responses from employers, both declining due to a lack of a current residential address. Because here's a piece of the system nobody talks about. You cannot get a job without an address. You cannot get an address without a job. That circle doesn't break itself. I stared at that packet for a long moment. Before I tell you my ruling and before I tell you what I decided, I want you to hit that subscribe button right now because what I'm about to say is the kind of thing that people clip and share for years, and I want you to be here for the next case too. Do you want to know what I think about excuses versus circumstances? Here it is. I have zero patience for excuses. Zero. Don't come into my courtroom telling me the dog ate your contract or that you didn't know the roof was leaking when you rented it. I don't deal in excuses, but I also don't deal in theater because there is a difference, a very real, very important difference between a person making excuses for bad choices and a person standing in front of a consequence that was manufactured by a system that failed them first. One is accountability avoidance. The other is a human being caught in a machine that chewed them up. Marcus Delaney made no excuses, not one. He told me the truth, brought his documents, and stood there with his chin up and his hands still. And everything he told me, the paper confirmed. Now, Forsyth. I turned to the city attorney. Counselor, the man in front of you is on your city's own housing waiting list. He has a case number issued by your own social services department. He was attending an outreach program that your own city helps fund. He was sleeping 30 feet from a public building that he was by instinct and training actively protecting. And you want 30 days in county jail and a permanent downtown ban. Forsyth opened his mouth. I'm speaking. He closed it. Do you understand what a permanent downtown ban does to a man who is trying to re-enter the workforce? It removes him from every social service office, every outreach program, every workforce agency, every public transit hub in this municipality. You are not removing a nuisance. You are removing his lifeline. And you came in here without having looked at his church sign-in records. That is not preparation. That is assumption wearing a suit. The gallery stirred. Gary's jaw tightened just slightly in the way it does when he knows I've landed somewhere real. If it doesn't make sense, it's not true. Charging a man who built a windbreak to protect your building for damaging the community, that doesn't make sense. Here is my ruling. All charges dismissed, not reduced, dismissed. Now, before you think I'm done, I wasn't. I called the city attorney and Marcus's public defender back to the bench. I told them this. Marcus Delaney was going to have a documented certified case conference within 10 business days. Not a suggestion, a condition of the city dropping these charges without prejudice. I noted in the record that the Millbrook Social Services waiting list placement process had a case with documentation suggesting systemic delay, and I recommended, formally in writing, that the city's housing liaison review wait time protocols. I'm an arbitration judge. I rule on disputes. But I came from family court in Manhattan, and I'll tell you what I learned there. The problem in front of you is almost never the only problem. It's the symptom. If you only treat the symptom, the disease keeps moving. Marcus Delaney stood very still when I read the ruling. He didn't cheer. He didn't cry. He nodded once, the way a man nods when he has been hoping for fairness long enough that he no longer assumes it. That nod hit me differently than tears would have. Tell me what you would have ruled in the comments below. And share this video if you believe that one document, one detail, one moment of actually looking can change everything. Because that's what happened here. Now, the update. 11 weeks after that Tuesday, I received a letter, hand-delivered through my producer's office, forwarded from the courthouse. No legal letterhead, plain paper, clean handwriting. It was from Marcus Delaney. He had been placed in transitional housing through the Millbrook program. His case conference had moved things forward. He was working part-time as a maintenance consultant for a property management firm that had, notably, found a way around the no-address hiring barrier by using the transitional housing address from day one. He wrote that he was saving. He wrote that he was 63 now and that he wasn't starting over. He was continuing. He said there was a difference. He was right. There is a difference. He didn't thank me for being kind. He thanked me for looking at the paper. That's the line that stayed with me. He thanked me for looking at the paper, because that's all it took. One sentence in a police report, one sign-in sheet, one document from a government agency that proved the city's own system had this man enrolled, waiting, trying, while simultaneously preparing to jail him for the consequences of that wait. Let me leave you with this. I don't believe in giving people passes because their life is hard. Life is hard for a lot of people who don't end up in front of me. The measure of character isn't how hard your road was, it's what you did on it. Marcus Delaney worked for 31 years. He showed up for a church program. He protected a building he didn't own in weather he was sleeping in. He brought his paperwork to court. He told the truth without decoration. That is character. And when someone shows me character, even when they're standing in torn shoes with a case number and a charge sheet, they will get fairness from me every single time. Not sympathy, fairness. There is a difference, and that difference matters. Consequences should teach. They should not simply punish people who were already being punished by the situation they were trapped in. That's not justice. That's convenience. And convenience is not something I dispense from this bench. Here's what this case really proved. The most dangerous assumption in a courtroom is the one nobody says out loud. The assumption that because someone is in a certain position, they must have done something to deserve it. That assumption is lazy. It's frequently wrong, and in a courtroom, it is unacceptable. I raised my eyebrow at a charge sheet. I read a police report all the way to the last paragraph. I asked one extra question about what a man did for 31 years. That is the job. If you've been watching me long enough to know that this is always the job, cutting through the noise and finding what's actually true, then hit that like button and subscribe right now, because there are more cases coming and not all of them end this cleanly. Some of them end with rulings that sting. Some of them end with people walking out angrier than they came in. Some of them involve people who are genuinely wronged and people who are genuinely lying, and the trick is knowing which is which before you pick up your gavel. I've been doing this long enough to know the truth is almost always in the details. The date on the form, the name on the sign-in sheet, the sentence at the bottom of the police report, the posture of a man who has nothing left to protect except his honesty. That's what I look for. Every time, without exception. Marcus Delaney walked into my courtroom a defendant. He walked out with a dismissed case, a court-mandated case conference, and his dignity intact. Not because I was soft, because the evidence was clear and the truth was plain, and doing anything else would have been wrong. In my courtroom, wrong is not an option I keep on the table. Tell me what you would have done in my position. Drop a comment below and be specific. And share this video if you believe that every person who walks into a courtroom deserves to have their paperwork actually read. But I'll tell you one thing, nothing, and I mean nothing, prepared me for what walked through my courtroom doors the very next morning. That case, it made this one look simple. Stay close.